Well, good morning, Cory. Well, what I told them was, that the hearing is no longer really about the open internet rules. What the FCC is doing now is going for what's called Title II, this reclassification of the internet as a public utility. That's much more worrisome, frankly, to many of us than the rules themselves. And what I did was, along with former Democratic Congressman Rick Boucher, urged the committee to act as Congress only can do in passing bipartisan legislation that would solve this problem once and for all without resorting to these crazy legal theories.
Michael Copps, is this a crazy legal theory, Title II?
No, I think the big ISPs have got their smog machines out to try to befuddle and confuse the media and the people and everybody else. Let's start with the very basics. We don't have a lot of time here. The question at issue today is whether an agency in Washington, D.C. is going to have the authority, as it has had since the 1920s over telecommunications, to make sure that there's no discriminatory actions by the providers, to make sure now in terms of the internet that a favored few aren't going to be able to throttle content or block content or prioritize content or determine what news you and I are going to get. The FCC has had this authority. The question now before it is it going to reassert this authority for the communications infrastructure of the 21st century that it did for the 20th century. It's not rocket science.
Well, I wonder, the ISP's arguments aside, we understand why they might have a vested interest in this argument, but there is an argument, Commissioner Copps, former Commissioner Copps, that Title II is not the best way to do it. Are there problems with Title II? Why is Title II the very best way for the FCC to pursue this?
Title II is the very best way because it's the only solid legal foundation. The courts have virtually told us that. If you want to do net neutrality rules, which the courts seem to indicate is something that the FCC is authorized to do, you have to do it under the right legal foundation. And when the Commission back in 2002 voted that cable broadband was not a telecommunication service, and then later the same thing applied to telecommunications generally, it wiped out the legal foundation to rest that argument on. Nobody can predict the exact outcome of what happens when these decisions go to court. Any decision would go to court. But if we're going to court, I want to go with the soundest and the strongest legal foundation there is, and it's clearly that's Title II.
Yes, Larry, we know the lawyers are going to get paid for this one. Someone's going to go to court no matter what. Why is Title II, Larry, in your opinion, not the right way to pursue this goal that I think most everyone has for an open internet?
Well, so I would have to disagree with Commissioner Copps about this. It's not the most solid legal foundation. In fact, what the court told the SEC and what the chairman acknowledged in January all through the summer was what the court said was Section 706 of the Act is solid legal authority. That's the way you should go. He said that was a roadmap, an invitation to reenact the rules under that authority. He was going to do it. The problem with Title II, of course, is that the Supreme Court, agreeing with the FCC, has said it does not apply to information services, does not apply to the internet, and that means that for the FCC to pull off this gambit, it's going to have to fight a much stronger uphill battle in the courts, possibly all the way to the Supreme Court.
I want to read a quote here. Commissioner Copps, I also want to respond to an issue that's come up in the hearings today about secrecy. There's a quote from two congressmen. I imagine them sort of arm in arm like a barbershop, half of a barbershop quartet. But they said together, Representative Upton and Representative Chaffetz said, so long as the chairman continues to insist on secrecy, we will continue calling for more transparency and accountability. Chairman Wheeler and the FCC are not above Congress. Copps, I wonder if you can help me understand why the FCC has not made the entire proposal public before the vote.
Well, I think, number one, is following the terms of the Administrative Procedures Act and sharing it with the other commissioners. It has already put out a fact sheet, and we'll know a lot more about it very, very, very soon. But you have to realize that this proceeding has probably the most complete record of anything that the Commission has done in years and years and years. I referenced that 2002 vote. The Commission's been compiling a vote ever since then. We've asked every question, or it has asked every question. Every issue that could possibly come up has been vetted. That you couldn't get a complete record. There's no need to delay this vote. And people who talk about other alternatives like legislation, my goodness gracious, I mean, when has Congress passed a substantive piece of legislation recently anyhow? And can you imagine how long that would take? Net neutrality has been put out on the sidelines here too long. It's time to do it, and it's time to do it now.